Have you been dismissed from work either because of your HIV status, being expectant, or because you went on leave? Join us as we discuss these and other matters on our Wakili Mkononi show. I am your host, Mercy Wanza. Today we're discussing the various rights and responsibilities of both the employer and the employee at work. We are joined in this discussion by our very able advocate of the High Court of Kenya, Mr. George. Karibu sana to our show. Thank you for coming. Now, let's get right into it, George. What are some of the rights that employees have at the workplace?
All right, thank you, Mercy. Our employees in Kenya are protected by the Employment Act. Now, the Employment Act provides various rights and also the Constitution of Kenya. One of the rights is a right to be given work. So an employee cannot just sit around and lounge in the office. A right to be paid for the work that they do. They have a right to be paid for overtime in case they work over their hours of service. They have a right to be given medical assistance in case they fall sick. We also have a right to housing. So an employer will provide a certain amount of money if they're unable to provide housing, what we call housing allowance, within the salary so that the employee can get housing. They have a right to rest 1 day a week. They have a right to leave, usually 21 days in a year. That is the minimum. They have a right to sick leave as well in case they fall sick, which is a minimum of 7 days. Basically, those are the main rights that we have in the Act and in the Constitution. They have a right as well to form trade unions and to participate in such like activities.
Wow, so we see there are very many rights that an employee has. But do we have also rights for the employer himself or herself?
I would say that an employer has the following rights. He has a right to demand for work that he has paid for. So as an employee, you are required to work for the salary that you've been paid by the employer. He has a right to demand for quality work, not just any sort of shoddy work. He has a right to protect his trade. So he will put in protections in the contract to cover him such that you do not give out trade secrets. He also has a right to protect his actual business. So there are provisions of confidentiality. There are provisions of non-compete, so you do not compete with the business of your employer, or you do not solicit customers of your employer.
Very interesting. Does an employer also have a right to terminate, of course, lawfully an employee?
Yes, he has a right under the Employment Act and the laws to terminate an employee who's performing poorly, or an employee who's misconducted themselves, or an employee who's incompetent to work, as long as he follows the laid down procedure.
Right, so those are the legal grounds. But are there some type of illegal grounds that exist where an employer terminates the employee's contract?
Yes, I would say they are not supposed to terminate if this happens. So for example, we have had instances where an employer terminates a lady who becomes pregnant. That one is very illegal. Or an employee who has joined a trade union, or an employee who has agitated for his rights at the workplace.
Right.
So those are some of the instances where an employer should not terminate, or an employee who is of a certain way, so you discriminate, maybe race, gender, religion, and you don't like this person, so you terminate their services. Those are illegal grounds for termination. The legal grounds are poor performance, misconduct, incompetence to work.
Now that you have mentioned that there's some type of illegal grounds, but let's take it back. We see that some instances where a woman, for example, falls pregnant and she goes to seek for work and she's not given the work as a result of the fact that she's expectant and not because she's not competent for the job. Is that also unlawful?
That's extremely unlawful. It offends the provision of the law in relation to discrimination. So an employer should not discriminate an employee at the point of appointment, during the employment, and at the end, for any reason whatsoever, be it sex, age, race, religion, class, or whatsoever. So you cannot discriminate a pregnant woman at the point of recruitment just because she's pregnant.
Very interesting. So now, assuming that someone has been now unfairly or unlawfully terminated, what are some of can an employee get justice?
Yes. The law has provided for mechanisms where an employee can get redress. One of them is what we call labor offices. So we have labor offices all around the 47 counties. An employee can walk into one, and there are labor officers who will handle their issues. What they do is they usually call the employer and the employees for a sit down, and they try to mediate that challenge if there's an issue, and they can make orders for reinstatement or for payment of damages. Also, an employee has a right to file a case at the Employment and Labor Relations Court. Recently, magistrate courts have also been allowed to handle those employment issues. So it will then follow the due process of proving your case. And once judgment is issued, an employee may be given a reinstatement, that is going back to his position, or damages.
Okay, so those are some of the remedies that an employee can get. Now, unfortunately, there's been a growing incidence where there's a lot of sexual harassment, especially at the workplace. Could you mention what are some of the actions that can be deemed as sexual harassment?
Okay, sexual harassment, in my view, is a very perceptive issue. So there are instances where a senior or an individual who's higher than you in rank can speak to you suggestively, or touch you suggestively, or offend you in such a manner that you feel that your sex has been brought into the picture, as opposed to merit. So those instances are really on the rise in the company's setup or in the employment setup, and therefore we need to sensitize employers and employees that there's a requirement to come up with a sexual harassment policy. So this sexual harassment policy, for example, if you're an employer who has more than 20 employees, you're required, as a matter of fact, as a matter of law, to have a sexual harassment policy. And within this sexual harassment policy, you must describe what is sexual harassment, the procedure for grievance, so that if there is an instance, how does one employee report, the procedure for handling that, and the repercussions for such action. And it should be taken very seriously, because it is a demotivating factor, especially for our female employees.
Absolutely. So what you are basically saying or advocating for, rather, is that all employers should have a sexual harassment policy.
They must.
It's a preventive measure towards sexual harassment in the office.
It is, and the policy must be known to all the members.
Right.
It must be issued to all the members. I also advise that once it is issued, all employees should sign against it, so that they confirm that they have indeed seen a sexual harassment policy and they have signed for it.
Very interesting. I think this has been a very empowering session, especially to anyone who has felt that they have been unlawfully terminated, and now that they know the grounds and also the repercussions for this, and also, of course, the sexual harassment policy, that's a preventative measure for employers in the workplace. So thank you very much, King, for joining us.
Thank you for having me.
Asante sana.
Asante.
We have come to the end of yet another episode. Many thanks for watching. For more information on simplified legal issues, log on to our website on www.wakilimkononi.co.ke. You can also follow us on our Facebook, Instagram, or Twitter handles @wakilimkononi. Remember, ignorance of the law is no defense. Until next time, ciao.